Good afternoon, everyone, and welcome to the bi-monthly State Breastfeeding Coalition's teleconference. We're going to go ahead and get started now, and I wanted to let everyone know that the teleconference is being recorded. We also have all attendees on mute at the moment. We wanted to let you know that we will have an ability to ask questions during the Q&A section towards the end of the call. You can actually type in your questions into the webinar screen. If you look at the toolbar towards the bottom, you should have a box that has questions. If it is minimized, you may need to click the plus sign next to the word questions, and a box will open up and you will be able to type your questions in there when we get to that section of the call. But this is our first call in webinar format, so we are very excited to try this out and are looking very much forward to hearing your feedback and thoughts on the format. So at this time, I will go ahead and turn it over to Jessica Allen from CDC, and she will introduce the call today.
Thanks, Megan. We're excited to have Amelia Psmythe and Mendy Mattingly with us today. They're going to be presenting on reasonable breaks for nursing mothers under the new federal law. So I'll introduce Amelia first. Amelia Psmythe directs the Breastfeeding Coalition of Oregon, where she's worked for several years to help employers and employees implement Oregon's rest break for breast milk expression law. Oregon Senator Jeff Merkley brought similar legislation to federal law last spring as part of the Affordable Care Act. Amelia's experience in Oregon is now being applied to the national conversation, informing breastfeeding advocates and drafting recommendations to the U.S. Department of Labor. Mendy Mattingly is an attorney at Littler Mendelson, the nation's largest labor and employment law firm, with more than 750 attorneys in 49 locations. She represents and counsels management clients in various areas of employment law, including claims involving discrimination and harassment under federal and state laws, wage and hour issues, and has drafted employee handbooks and employment policies. Within Littler, she has become the firm's lactation accommodation expert and has written the firm's sample national policy, newsletters, and blog entries on the subject. She is also a board of director for the San Diego County Breastfeeding Coalition and breastfed her 2 girls for over a year after returning to work. I will turn the time over to Amelia and Mendy.
Great, thank you so much. This is Amelia, and I'll start out today. I wanted to thank the CDC and USBC for giving us the opportunity to speak on this topic. And also, on behalf of all the coalitions, I want to thank you for continuing to forward the technology of these calls. It really gives so many more people the opportunity to take part, and building this kind of communication infrastructure supports all of our work as coalitions. So I thank you for that. So today, Mendy and I are going to share some insights into the new federal law, reasonable breaks for nursing mothers. So next slide, please, Megan. So I'm so pleased that joining me to share in the legal interpretations of this law and some examples of employer questions is Mendy Mattingly from Littler Law's San Diego office. So I've spoken with a lot of labor and employment lawyers across the country since this law went live, and Mendy's been by far the most generous with her time and the most accessible with her explanations, and significantly has been the only one who's actually working directly with employers. So she's advising them about this law, she's providing them with sample policies, and she's giving them real-world solutions. So I thought it would be incredible if we all had the opportunity to learn from her directly, as she is one of the key people that's informing employers around the country. So thank you, Mendy, for being here on our first National Coalition webinar.
Thank you, Amelia.
Yeah. So the next slide, please. So it looks like on my viewer, I'm not seeing the slides advancing, Megan. Do I need to be doing something? Sorry about that. I think I just hit something, so I will be right back with you. Okay. I'm just going to give a little background. So the Reasonable Breaks for Nursing Mothers law was sponsored by Oregon Senator Jeff Merkley, and it's based on a similar law that he helped to pass as Oregon House Speaker in 2007. So it passed as was mentioned in the introduction, as part of the Patients Protection and Affordable Care Act, which we all call healthcare reform. But what it amended was the Fair Labor Standards Act. So to understand how the law works and what it does and doesn't do, it's necessary to understand a little bit about the statute, because what's written in the amendment is interpreted in part by where it's placed within federal statutes. And that informs lawyers like Mendy on what this kind of legislation really means to employers, and it tells advocates like us what we really accomplished and what we still need to do. So big picture, this law sets a minimum standard for lactation accommodation nationwide. And that's something I think we can all celebrate, even as we think strategically on the next steps of the policy work we still need to do in this country. So I'm going to go to, I guess this is the fourth slide when you catch up, Megan. So why protect breastfeeding in the workplace within healthcare reform? So the general public has tended to think about healthcare reform as this really complicated piece of legislation that was related to how a patient and a doctor interacted, and then whether or not their insurance company paid for that, right? But I think that most people working in public health recognize that the real opportunity and genius of healthcare reform was, gave us the chance to articulate public health policy and disease prevention strategies for the country, of which breastfeeding plays a major role. Have a lactation accommodation program in place in order to meet these public health goals. So Megan, should I pause or keep going?
No, please keep going. My system is telling me that everyone can see the slides, so I don't know.
Okay.
Can you see anything?
Okay. I am only seeing the title slide, but either way, I'm happy to keep going.
All right. Why don't you go ahead and keep going, because the slides are available on the website in the usual way as well, and I will contact technical support. I'm not sure what the problem is.
Okay. So I'm on slide 5, which asks the question, why is the law necessary? So many of you might have seen the new breastfeeding awareness campaign that originated in Kansas, and it's running with the slogan, because you don't stop being a mom from 9 to 5, right? Women comprise nearly half of the U.S. labor force, and that means a whole lot of the people who are at work are moms. And in fact, we know that the fastest growing segment of the U.S. labor force is women with children under 3. So we've had a hodgepodge of state laws in existence, and it doesn't set a uniform standard of what appropriate accommodation looks like. And it also doesn't set any kind of consistent mechanism for how we can go about enforcing these types of laws. So we needed a federal law to set a minimum national standard for what these workers need in order to be healthy and in order to be productive. So in Oregon, we've used the slogan that women should never have to choose between a paycheck and their baby's health. And that's what we're going for here, the world we're trying to create, so women can be productive and brilliant workers and mothers at the same time, and that they can be supported. They can count on being supported by the larger culture. So slide 6, what does an employer gain? So thanks to all the hard work of folks at the Maternal Child Health Bureau, we have the comprehensive business case for breastfeeding toolkit. And we also have 30 states and territories that have been trained and supported on projects related to using that toolkit in their communities.
Amelia, may I interrupt you a second? This is Carol McGowan. Megan, your email is up on the screen. You might want to, Megan?
I'm here. It's telling me that PowerPoint is showing, so I'm afraid that my internet connection is probably the issue. I'm trying to work on it as fast as I can, but please bear with me. I'm sorry. I think it is my internet.
But we're looking at your email. You may want to figure out how to minimize that part.
Okay. I don't know that I can stop it because I think it's about 20 minutes behind where we actually are.
Sorry, Amelia, go on. Sorry.
No, that's okay. So I was just trying to summarize the comprehensive business case for breastfeeding toolkit in a few short bullet points. If you've seen the materials, you probably are very familiar with these sound bites. If not, you can get your hands on them and download them for free on the Office on Women's Health website. But the real takeaway is that these kinds of projects actually give money back to the Human Resource Department. They don't deplete the funds, they give it back. And that's because worksite lactation programs lower absenteeism, lower healthcare costs, lower employee turnover, and create higher job satisfaction. So a real basic program like this law provides with a minimum standard of time and space accommodations, for every dollar that's invested into the program, there's a $2 return. If an employer has a comprehensive program, like with a written policy or access to lactation consultants or flex time or child care, then for every $1 that an employer puts in, there's a $3 return. And so these are really significant numbers. And I hope that it encourages all of you to feel comfortable going out and talking to employers and advocating for these kinds of programs. Because when you do so, you really are helping the employer and the overall economy, not just moms and babies that you work with. So I'm on slide 7, called When Did the Law Take Effect? So the law was effective when the act was signed. It was pretty sudden. It was pretty sweeping. If you remember, it was a really big, dramatic moment in our country. And since that time, advocates have been working hard to understand and to support the process of implementation around this law. So at this time, the U.S. Department of Labor has not issued guidance, but they have given us fact sheet number 73. And when you get the PowerPoint, you'll see that we've provided a link for you there. So the Department of Labor has said that they will issue guidance and additional information soon. But in talking to them, my sense is that it's not what we do know is that the state branch offices of the USDOL will be administering this law. And so what that means is that in your state somewhere, there's a person in an office who is going to be the one that employers and employees go to when they need information or they have when they have complaints. And so I strongly suggest that every breastfeeding coalition seek out that person, seek out that office, and make the connection and offer yourself as a resource. So I recently met the director of my State Department of Labor office, and it was a very reassuring encounter. I learned that he was really clear and aware about the law, that he recognized and understood it was very time sensitive, that if anything comes up, he needs to respond immediately and help find solutions. He also understood that employers might not know exactly what they need to do, but that by and large, they would want to help to do the right thing and to be in compliance. So he seemed happy to know about our coalition and to know about the business case for breastfeeding toolkit trainees. And again, I just encourage you all to go and find that what have advocates done to support the process. So you should know we've done a lot. We've worked with Senator Merkley's office to review the amendment before it was put into the Health Care Reform Act, and we've helped with media outreach since. A group from the United States Breastfeeding Committee with substantial heavy lifting from Chris Mulford provided the Department of Labor with a cited background paper It included things like the physiology of breastfeeding, the history of legislative actions, what breastfeeding accommodation looks like in the workplace, and so on, all with the intention of informing their work. You know, the Department of Labor are experts in the Fair Labor Standards Act. They're not experts in breastfeeding. So we've tried to step in and fill that role. Megan Renner and I have also worked with a group under the leadership of the National Partnership for Women and Families. This is a Washington, D.C.-based advocacy organization, and they helped us carefully review the amendment and to craft suggestions for the Department of Labor to use in their fact sheet and the eventual guidance that they'll be issuing. In addition, there's a team of federal health officers from CDC and Office on Women's Health and Maternal Child Health Bureau that Megan and I are talking with them and all together talking with the Department of Labor about what kinds of resources are going to be most helpful. One of the ideas on the table is creating a national searchable database of non-office pumping solutions. This is something where people could go in, and if they're a Pizza Hut, they could type in Pizza Hut or fast food restaurant and come up with real-world examples about how lactation accommodation is working or happening in those various environments. We're also talking about what are the best ways to link employers and employees with the breastfeeding coalitions and the Business Case for Breastfeeding Toolkit trainees. So at the end of this presentation, I'll tell you more about what you can do today, but I want to turn it over to Mendy to talk more about details of what this law does and doesn't do. So Megan, she'll be starting on slide number 9, which is titled, What Does This Law Do?
Thank you, Amelia.
Yeah, if you can advance a couple more, Megan, I think you'll be there.
Thank you again, Amelia, and thank you for having me. Really simple, what does this law do? It provides the two things that most women need when expressing breast milk in the workplace, time and space. And it provides a reasonable break time that really matches or attempts to match the rhythm of the nursing, you want to say dyad, or the structure of a workday, so that it's not limiting, which I think is a good thing. What does the law actually say? And if you can advance to the slide 10, that would be great. In detail, and I try to sum it up really quickly because these are the different highlighted provisions, is a reasonable break time each time the employee has the need, and a place other than a bathroom, and it's unpaid. That's pretty much the 4 big chunks of the law, and then it provides a time limit until the child's first birthday, and the other key issue being that state law is not preempted. One thing I do want to reemphasize that Amelia mentioned is that this amends the Fair Labor Standards Act. So I have put the citation to where it is in the law, and it's the 29 U.S.C. Section 207R. And that becomes increasingly important as we start to analyze and look into the details of the law. So at slide 11, what does the law say? What does it mean to have a reasonable time? And a lot of questions are coming in about how much is reasonable. One thing that is potentially good for moms is that it is intentionally vague, and reasonable to each person is going to vary. The DOL fact sheet pretty much emphasized that when they said, as well as the duration of each break time will likely vary. And the fact sheet is looked at right now as our only additional guidance beyond what the actual law says. The DOL fact sheets are not going to carry the same weight as regulations or official interpretations. The effort is to match, again, the biorhythm that each mom may be different, and each length of nursing break will vary. Most people, depending on the location of where the break room or the area that is set aside for to express the breast milk, will need around 10 to 15, up to 30 minutes every few hours. And again, that's going to probably depend on when the mom came back to work, how long she's been back to work, and will change over the course of the time in which she expresses breast milk. She may have 3 breaks at the beginning, 10 to 15 minutes each. It may go down to 1 longer break. Again, I think the law was left intentionally vague to say no one mother or no group of mothers is going to all fit and be able to express breast milk within 10 or 15 minutes. at certain times each hour. And then the other thing, and a lot of things that I'm educating employers about right now, is truly the logistics of this, that it takes time to get to the location where the room is set aside or the area is set aside, to set up the pump, to actually then go through the expression process, to clean and wipe down the process. I mean, it's really the logistics that a lot of people at this point are not understanding, above and beyond what the law says. So if we look at slide 12, we're talking about what is a non-bathroom space. And this is probably the area that I've received the most amount of questions in. The law only says it must be shielded. It's a private or a space that is shielded from view and free from intrusion from coworkers and the public. And then on the DOL fact sheet, again, the emphasis was a bathroom, even if private, is not permissible location under the Act. The other good thing that came out of the DOL fact sheet is just a tad bit more guidance on what types of spaces are going to be appropriate, and one that is functional for expressing breast milk, and one that is available when needed. So again, you can't necessarily, by the language of the law and what the DOL has put out to date, I don't think a conference room that is booked solid all through the day is going to be appropriate, because it's not going to be available when needed. It can be a temporary location. It doesn't have to be, and the law does not require that a permanent space be built, though that is often my recommendation to employers, is if they have the space available, it is easiest, and if they have numerous mothers who are needing this accommodation, it is easier to have a permanent space so you don't have this rotating, where are you going today, express breast milk. It makes it a lot easier and smoother for, I think, everybody involved. I do have where employees are assigned to different locations each day, at different buildings, if you will. So if the area does need to be a rotating room, that's fine. A curtained off area has been, I think, deemed appropriate, or will be deemed appropriate, because the language in the statute, again, is not something that says a room. It just says a place that is shielded from view and free from intrusion. So anything that we can kind of curtain off would be, would seem to be applicable or appropriate under the law. Ideally, you want a clean and private space. Ideally, you want a permanent space, but not every employer is going to have that ability. And the other issues is the chair, the table, the sink, an outlet, and a fridge. If they have those means, if the employers have those means and mechanisms to provide for that, I certainly would recommend that. Obviously, a chair is probably the most necessity of all of those things. Everything else is probably in the workplace nearby, or there can be alternatives provided. So on slide 13, we talk about what types of employers. And I think this is the thing that at least I'm seeing in the blogs and online that is most inaccurately quoted. Because a lot of times it says that it only applies to employers with over 50. And I think if you read the actual language of the statute, that's untrue. It applies to all employers that are covered by the FLS Act, or the Fair Labor Standards Act. If an employer has under 50, then they may argue there's an undue hardship, but there's no guarantee of that. So realistically, this does cover all employers regardless of the numbers, unless they can make that argument, and that argument's a pretty high threshold. The undue hardship question was probably one of the first questions that we got a lot on, is whether or not that undue hardship is available for employers that employ less than 50 in one location. The DOL's fact sheet has made that also clear, that it's 50 regardless of where they're located. There are other employment laws that have a geographical limitation on this, and it's just not written into the statute, and therefore the DOL says it's 50 wherever they're located. The undue hardship is considered in the totality of the circumstances. So if an employer tries to argue this, they're going to have to show that there's a significant difficulty or an expense, and that is in relation to the size, financial resources, nature, or structure of the employer. What I have been, explaining to some employers is realistically, you're not required to build a room, so that would certainly be a lot more expensive. But a curtain or a room divider or a partition of some sort is going to cost less than in a chair and a potential table, all of which, the chair and the table can be borrowed most likely from a lot of different places in the workplace, but is all of which could be probably done under $500 if need be. So I think that threshold is going to be really hard, but I think that is the most often quoted or misquoted portion of the law on a lot of the blogs and other online commentary that I have reviewed. So on slide 14, we look at what does the law say as to the type or the classification of workers. And this is where we look into, again, what Amelia was saying is where this law is placed in relation to other statutes or subsections of the statute. And it is going to cover the majority of the workers, but some are going to be exempted under Section 213A and B of the Fair Labor Standards Act. The workers that it is covering is the hourly workers, the non-exempt workers. In most all of the different industries, there are going to be a few industries that are exempted, but the ones that are covered are the ones that are probably more often to bring Fair Labor Standards Act claims or charges, and you're looking at your hourly workers in retail, restaurant, call centers, daycare, things along those lines. And Amelia made sure I pointed out that this means most of the WIC moms that I think a lot of the coalitions are working with. So the vast majority of the mothers are going to be covered. And remember, it's even if they're at a small employer with less than 50, because that employer would have to have argued the undue hardship. So you don't need to ask, and I'm not asking, whether or not they're under 50 or over 50. It's if they start coming up with this is too expensive, we really look at whether or not it's going to fit with their financial resources. So at slide 15, what the law doesn't say. It doesn't say in close proximity to employees' work area like the statutes in California or Colorado and a few other state statutes say. So the location in which the mother can be put may be a good walking distance from where she normally works every day. And that's something that I've also been counseling employers on, is saying the closer you can get to the mother, the less time it's going to take. And again, things like that are just the logistics of it that sometimes employers are not very familiar with. The other thing it doesn't say is that all employees anywhere are covered. And we talked a little bit about that. Specifically, I think most people know that now the salaried exempt individuals like executives, administrative professionals are not covered under this because they're not covered under the overtime and minimum wage laws of the Fair Labor Standards Act. And the other big group of employees that are not covered are teachers. And I think those are the teachers, I believe, are going to be the most difficult people to accommodate, but I do know that there are schools out there doing that. So I think that's an area where the coalitions can really work and find some solutions. Even though that some of these categories of employees are not covered by federal law, if there is a state law, it still may apply to those employees. For example, in California, the law applies to everybody, regardless of the employee's classification. The other big thing that it doesn't say is paid. These are not paid breaks under the law. And there is some debate and argument and analysis going on regarding that and how that plays out. And it's a little questionable on that. But it right now does not say that these are paid breaks. It says that these are unpaid breaks. So at slide 16, why doesn't it cover everyone? I think that if you understand the history of the healthcare reform a little bit, you might understand and just kind of as a part of the whole package, but not each and every section was looked at individually. The other big advantage, I think, legislatively is that it covers the most amount of workers and the most vulnerable hourly workers in having the Fair Labor Standards Act amended. So it is placed in a section that's going to cover the most amount of individuals that are in the workplace that likely need this type of accommodation or assistance. The law will likely start to change the workplace culture from the lower wage earners up. A lot of times I think the office professionals or the exempt level professionals who have their own office either can pump or have a policy at work that allows them to do so in their office. So this is really going to, I think, change the culture, and is one of the targeted reasons why you kind of need to go after the lower hourly wage workers. And the other good thing for us attorneys, at least, is that the law is not necessarily done. There's a lot of discussions going on about healthcare reform, and this is going to be a long process, I think, over the course of a few years. Legislative action is often increasingly incremental. It takes, and in this situation, appropriately, baby steps to get to where I think we will eventually end up. So with all of that said, the couple of things that I do want to do a reminder on is, even though there are some things that it doesn't say and there are some people that it doesn't cover, if we go to slide 17, it doesn't preempt state laws. And again, I see this a lot of things stated various ways about how many states actually have workplace accommodation laws or lactation accommodation laws. And I want to point out that only 14 states actually require employers, and the District of Columbia actually require employers to have an accommodation. Montana's requirements only relate to public employers, and the other 9 states that are also often lumped into these workplace just have encourage or permit accommodations. Sometimes it allows the employer to say that they are infant friendly, but there's no penalty, there's no requirement the employers comply. So they're again an example of how legislation is often incremental. That might have been the first step and the easiest way to get that legislation passed. Eventually they might put into law in those states something stronger if the federal law doesn't step in and pretty much cover that particular either classification of workers or employer. The most detailed and strongest law that I think is out there is probably Oregon, which is something that's been nice working with Amelia, because she has been instrumental in working with Senator Merkley in Oregon, and he is also the one that introduced this in the federal health care law. It's by far the most detailed law that's out there, and sometimes that's good, but again, when you put too many parameters on it, there's not enough flexibility. So I think that they have already started to look how the federal law does more, protects more than the state law. But what I'm telling employers is that it doesn't really matter, because for employers that are required to comply, they're required to comply to both federal and state law. So they've got to overlap them anyways and look at both laws in order to make sure that they're not in violation of either one. So again, the federal law provides the minimum. It's definitely not the maximum. There are some state laws out there that provide protection for longer and that do cover all employees within the workplace. But the federal law provides a nice uniform protection for all the states. The biggest question that I think a lot of people are talking about is the enforcement issue. And we're looking at slide 18. And I say in some circles that they're talking about the enforcement issue. I have some really good news on this one. The USDL is still working on the issue in terms of enforcement. As Amelia mentioned, they're framing it broadly so that it can be flexible. The word is out that they are to act quickly on this. It's the state branches that will administer this. Any complaints, penalties, exemptions, etc., are going to go most likely to the state branch first. Now, whether or not penalties will be assessed for this is getting into some detail of the law. Under Section 216, for the most part of the Fair Labor Standards Act, allows for penalties, but those primarily pertain to minimum wage and overtime. They don't really talk about breaks. And since this is written in the law as an unpaid break, there's no amount of money that the employee is really missing out on because it's unpaid. However, there are some mechanisms, if you will, and the DOL and the Secretary of Labor can bring an action for injunctive relief. And sometimes that is a good thing, and sometimes it's more challenging to do that. So there are some mechanisms for enforcement, but they're largely unknown right now. And I think in some ways, you know, at least my recommendation to my clients is always you don't want to be the test case. You don't want to be the one that violates the law to see what the penalties are, see what the enforcement mechanisms can be. The other thing I think on a positive note that I want to share with the coalitions is overall the questions that I'm getting from our clients is not what the penalties are, but rather how do I comply with this? It's not how do I not comply with this law and what are the penalties for not complying, but is what do I need to do now? And I think that's something that is positive. If we move to slide 19, a little bit more in depth, what are employers doing now? What are their responses to this law? One, I've gotten a lot of calls for national a few questions that I am receiving, just kind of the practical implications so that you all understand, you know, what are some of the challenges that are being faced out there in the workplace. So if we look at slide 20, like I said, I think I mentioned earlier, by far the biggest question I am receiving is the location, where to put these employees, and given the constraints. And some of the constraints that have been expressed to me is that the only location that they have is the manager's office, and in the manager's office is personnel files, a safe, and a security camera that is not easily turned off and that cannot be turned off by the individual location. So what do you do, and where do you put the employees on that basis? What I have recommended for that is whether or not there is an area reach, if you will, maybe right underneath the camera, and see how and whether or not that would work. Again, it's kind of hard because I'm not physically in these locations, so I ask a lot of details about the layout and about how the rooms are. The other thing I've recommended is whether or not that's a client or employer that has a corporate headquarters that the employee can use if it's not very far, or if they're in like a strip mall and can access shared business, such as a large grocery store chain that might have more offices available. Some of the other questions are a break room that's shared by all. There's no other there's no other office location other than the break room because they're all in cubicles kind of out in the front, if you will, and the only area private is the break room. Fast food restaurants without any offices has been probably the biggest challenge. Contractors sent to other locations. So if you think of security forces or janitorial services, or even the people that come and water plants within office buildings, what do you do and whose obligation is it to provide that location? Spaces that are under construction, they did have a space, but it's right now temporarily under construction. They want to know if that fits in the undue hardship realm. Campuses with multiple buildings, but only one designated mother room. So some of the universities and other type schools, or even large employers that have truly a campus with a lot of buildings, but their designated mother room is in the one building that's at the top of the hill that takes 15 to 20 minutes just to climb the hill, if you will. What do you do in that situation? Again, employees working in multiple locations, whether or not a space is needed everywhere. And again, my response to that is if you can designate a space everywhere that's closer to the employee, that is going to cut back on the amount of time that the employee needs to take away from work to express this breast milk, and it is definitely the better option. Whether or not it's absolutely required by the law, I don't really think so, because there's not the close proximity issue. But whether or not it makes good business sense, absolutely. And that's kind of where I sit on a lot of those issues, is there are things that may not be required by the law but make very good business sense. And oftentimes, again, that's just explaining the logistics of expressing breast milk in the workplace. So the other set of questions, and I'm on slide 21, is the break time. How to provide this reasonable amount of break time given the constraints. Again, employers with only one person scheduled at a time of day during the day, and this is usually in retail. So the morning shift only has one person. They start to beef up their staff, a few hours into this. Because the law says that the break time must be provided each time the mother needs a break, how do you work that into the schedule? Do you have to hire more people and increase the payroll in order for this mother to go take her break for lactation? And then the other one that kind of shocked me, frankly, is if the regular paid break was already taken and the example was given to go smoke, do we have to provide another one to express the paid milk? And my answer to that is yes. Nothing in the law says that they have to use their already paid break time for this. Most mothers, however, I think will choose to use their already paid break time for expressing breast milk because they just don't want to be at work any longer than they need to. Again, this is a way of delivering a product to the baby, that is the breast milk. Ideally, breastfeeding the baby together is truly what that mom's goal will likely be. So again, expressing a lot of those types of issues that employers probably don't need to worry about as much. And then again, the question, can we mandate that the employees use their normally scheduled break pump? It's the same answer. I don't think that the employers can mandate it because the law doesn't suggest that, but most mothers are going to want to do that anyways, I think. How long do we have to provide the breaks? That's very clear in the law, is up to 1 year. For employers that provide it longer than that, that's a whole different discussion, but certainly that implicates some of the state laws too. Whether or not, if it's less than 20 minutes, do we have to pay for that? And again, that gets into some of the details of the federal regulations and some of the state laws. And by and large, you I ask the clients the questions, do you already pay for break time less than 20 minutes? If so, how much? And if so, you can't really, and I don't think it's wise to carve out this, well, because you're lactating, we're not going to pay you for that time that you normally would get to do anything else. So some of these questions is overthinking the law in some ways, but I think they're good questions that the employers are asking, and I think it's great to have this discussion, I think, with a lot of them for the goals that we've all discussed and know about. Again, and then it gets down into the details. How much of the break time do we have to pay to be in compliance with the state and federal law? Again, the DOL fact sheet kind of made this a little bit more clear, that says, to the extent that a break is being paid under state law or the employer's policy, you need to continue paying the nursing mother for those breaks. About is how can we make this work and what solution can we come up with together given some of these parameters and given some of these. And I think sometimes the coalitions can really assist in that process because you have the ability to go out into the workplace and actually physically look at a location, which I think sometimes people just need to look at a space differently or more creatively. But initially the employers think, I don't have a room. And my response to that is you don't need a room. That would be ideal, and it would be great if you can get there, but we can do this without having to build a room. So again, it's walking them through the solution is the biggest thing I've been trying to do for the last 6 to 8 months that this law has come out. And with that, I'm going to turn it over to Amelia, or back over to Amelia.
Yeah, thank you so much, Mendy. I'm sure you can all see Cynthia Gem. So hopefully you're all wondering what you can do now. I'm going to just whip through a couple ideas for you, and then we'll have a little bit of time for questions. So make contact with your business case for breastfeeding toolkit trainees in your state if you haven't already, or download the materials. The Department of Labor has asked if it would be appropriate for them to build links so that if they get inquiries, can they refer people to the state coalitions or the toolkit trainees? And that's something I think each coalition has to think a little bit about. How would that work in your state, or would it work in your state? As I said earlier, definitely try to get to know the person at your state branch DOL office and make yourself known as a resource so that they know who they could call if they need to. You can read more about the law. There's a lot of different places you can find fact sheets. Of course, the Department of Labor fact sheet is the big one. There's an FAQ page on the USBC site, and there's also National Partnership for Women and Families. They have some information out. And what Mendy has on her Littler Law site some blogs that she's written about this law. When you talk to breastfeeding employees and employers, do so in the spirit of collaboration and really support the mom in being solutions-oriented. She's going to get so much farther if she approaches them with the right attitude. And similarly, you can support the employer in turning to the employee. You know, the employee might very well already have something in mind about where she's hoping to pump, and the solution might be a lot more simple than the employer has thought about it so far. We all can continue to be lobbying for the Breastfeeding Promotion Act, right? Because that would make the lack of breastfeeding accommodation a component of sex discrimination, which would offer stronger protections and better remedies. And that is still out there with Carolyn Maloney, and we can all get behind that effort. But whatever you do, please make sure that you document. Take pictures, take notes, you know, so that you can be sharing your wisdom with everybody else, especially wherever we are able to implement this in a non-office setting. Definitely record that so that you can help move this whole thing forward. So we have just a few moments left for questions and answers.
Wonderful. Thank you, Amelia and Mendy. This is Megan. Can you hear me?
Yes.
Yes.
Wonderful. Well, I will first address the number one question. I did send a chat message out to all participants. I am aware that the system is not updating. Do not be alarmed, because the problem is not you. All of you, hundreds of people on the webinar, are doing exactly what you're supposed to be doing, and my internet is actually, I believe, being illegally throttled by Comcast. So I do apologize that we have not been keeping up with the speakers. I am watching it as it takes 3 minutes to advance. So many apologies. The slides are up on the website. I did post a link to the chat, and it's also in your confirmation emails and easily accessible from the USBC homepage. So if you need to download the slides, they are available there. I do have a number of questions, so I will start going through these now. If you do have a question that you have not typed in yet, do go ahead and type it in. We will address as many as we can in the next few minutes, and if we don't get to them all, we can try to address some of them afterwards. So the first question that I have should be a simple one, I believe, from Megan Finkel Day, I believe. Can you please address if it's legal to all other staff, assuming that it's stored in proper bags or containers?
Do you want me to take that one, Amelia?
Yeah, sure.
It depends on the state in which they are operating. The only state that has something related to, I think, refrigeration is Indiana, if I'm not mistaken. I think Oregon addresses it a little bit. Whether or not if it's legal is not addressed at all under this federal law. The storage of breast milk is not addressed at all under the federal law. So there's not a whole lot of guidance about that out there. I wouldn't say that it's illegal.
Yeah, and this is Amelia. And OSHA has addressed this. They have a fact sheet on their website available for download. And the statement is pretty straightforward and affirms that breast milk is not a biohazard, and therefore there's no danger to anybody else by having the breast milk in the refrigerator. And interestingly, it ends with the comment, put the breast milk in an unmarked bag, and that's the best way to take care of it for all parties.
Okay.
The official answer is just hide it and store it.
All right, here's an interesting one. Many states are in the process of suing over the constitutionality of the new health care reform bill. How will this affect our efforts to move forward if we live in a state that is suing?
Do you have a guess, Mendy?
Oh, really?
I'm interested in the answer to that.
And I was expecting more simple questions. You know, at this point in time, what I have read is that, you know, some of those lawsuits are going forward. Others, the healthcare reform is fine. Honestly, I would not worry about it until there's an order or decision. And I hate to give this answer, but you know, continue down the path and sit tight, because I don't think that there's going to be a clear decision on that whole aspect for a while. But that is probably one of the downsides of wrapping up this breastfeeding within the healthcare reform. And I really don't. I haven't really looked at how that's going to impact this specific section of the healthcare reform. I was not expecting that one.
Here's a one that you probably are expecting. Does the law apply to individual franchises, fewer than 50 employees, for large chain restaurants? This is one we get a lot.
Yes. I don't think there's any carve-out there. They're an employer.
Mm-hmm. Okay. And even when the individual franchise has fewer than 50 employees?
Yes, and again, back to my statement is I think that's the most misquoted part of the law is it applies unless they can show that there's an undue hardship by looking at their financial resources and the difficulty in expense in complying with this. I think it's a hard burden.
Okay. We have a question. Any suggestions for how to find the person in your state with the Department of Labor to contact regarding the business case for breastfeeding?
I'm going to let Amelia take that.
Yeah. The contact for the business case for breastfeeding toolkit is going to be on both the Office on Women's Health website and the Maternal Child Health Bureau website, where the larger information is found about the toolkit.
for the use of the WHO growth charts for the assessment of children 0 to 24 months of age. These are new recommendations coming from CDC, and we expect will change clinical practice across the country. For those of you not familiar with these, the WHO growth charts are based on children who were predominantly breastfed for 4 to 6 months and continued breastfeeding for at least 12 months and set a new standard for growth. The second announcement is I'm happy to say that CDC was successful in awarding a contract for the 2011 iteration of the MPINK survey. So the survey has been funded and is underway for 2011. Right now there is out on the streets a 30-day notice announcing the data collection for the MPINK in 2011. Some of you have commented in the past the value of this survey, and if you would like to do so again, you can do so through the website of the Federal Register to tell them that MPINK is valuable to you and grease the wheels on our approval for that. If you have interest in doing so, you could send an email to omb@cdc.gov, which is the Office of Management and Budget, and say that you're providing comments reference to project 0920-0743. Alternatively, you could go to the website and just Google Federal Register MPINK 30-day. Those 5 key words there will help Google find you to the site that actually gives you the Federal Register notice about the data collection for the 2011. The third announcement is that CDC was successful in releasing the 4th iteration of our state breastfeeding report card in early September. This annual report, for the first time, reported that the Healthy People 2010 infrastructure that we need to support women. And finally, we continue to work with the Office of the Surgeon General and others at HHS on the release of the Surgeon General's call to action to support breastfeeding. We still do not have a firm date of release, but we're hoping sometime in mid-November. We've announced before our hopes, so we still don't know whether we will be able to do that or not. There have been a number of reasons for delay as more and more people get engaged at high levels in Washington, which is a very good thing that they are engaged, but it means the more fingers there are in the pot, the more that needs to be coordinated. So I think it is a good thing, assuming this eventually does come out in mid-November or sometime soon after that. But we continue to be hopeful, and we're getting much closer. That's all I have in the way of announcements. I'm going to close out the call, Jessica.
Sure, I think you all have your regional calls now, so thank you for attending, and make sure that you go online if you want to listen to this again or see the slides. Megan, anything you want to add? Guess not. Goodbye.